I'd encourage you, if you have any questions as I'm going through things, just to raise them. That'll avoid me proceeding on the basis that you understand some assumption that I'm making that I haven't clearly articulated about Australian law, and mean that we can move on pretty quickly. I will start just by posing some questions, and then I would like to give you something of a rundown of the Australian federal system so that you understand the way the system operates and the context in which the questions arise. But I raise these matters at the very outset for you to think about. We have the same administrative law doctrines in Australia as operate in England, subject to a couple of exceptions that are important. But doctrines such as error of law, failure to take into account relevant considerations, taking into account relevant considerations, improper purpose, bad faith, etc., are all doctrines of our administrative law as they are of English administrative law. And the particular ground that I wanted to talk about was the question of reasonableness and the extent to which that's a ground for judicial review in Australia. You may be aware of the traditional Wednesbury test, and that is no reasonable person, the decision that was made was one that no reasonable person could make, and therefore was invalid. That, by and large, has been the test in Australia for almost as long as it has been in this country. And the number of cases where that test has been satisfied has been extremely small. So perhaps a handful of cases where that test has been satisfied. So ironically, the test is perfectly clear. Basically, it's so hard to satisfy that generally it's not worth raising. Now, I've been a judge since 2001. I moved from the Supreme Court to the Federal Court in 2006. The court I sit on is just under the High Court. The High Court is the equivalent of the Supreme Court in the United Kingdom. The court I sit on has a large migration jurisdiction. So people coming to Australia who are non-citizens and who are applying for visas. Generally, most of the cases are protection visas, but they're not all those sorts of visas. They can go through an administrative process, starting with a delegate of the minister, proceeding then to the Administrative Appeals Tribunal. So to that point, it's all administrative. They then have rights of judicial review, and they come to the Federal Court, and then if the High Court, if they've got a special point, for example, they may get leave to appeal to the High Court. There are a large number of those cases. There have been a large number of those cases since 2006. I don't think I've seen in that particular area a successful Wednesbury ground of challenge in any of those cases. There have been plenty of cases where the court has said you haven't taken into account a relevant consideration, or you've failed, or you've taken into account an irrelevant consideration. But Wednesbury has come up on very, very few occasions. So up until about 2013, the position was reasonably clear. It was a ground of judicial review, but basically it wasn't very effective. In 2013, the High Court loosened the Wednesbury test in a way that I'll indicate during the course of my talk. But it's not terribly clear what the test now is. One of the reasons I chose this to do my research is I wanted to see what the English have done about the Wednesbury test. How have they applied it? Are there any lessons to be learnt in Australia? And I think, well, these are the possibilities. The first is that Australia would adopt a variable intensity of review depending on whether common law rights are involved or not. So that's the variable intensity option. I think that's possible for reasons I'll explain, but it's not the position at the moment. The second is that instead of the test being, is this decision so unreasonable that no reasonable person could make it, why not ask simply this question: could a reasonable person have made the decision? Now, Lord Cook, in a couple of cases I'll mention, has suggested that that might be the appropriate test. So you say, here's the decision. Could a reasonable person have made this decision? I think the problem with that as an option is that you need some form of further elaboration of what that is actually about when you say, could a reasonable person have made that decision? It's very easy to use phrases like, this is not a merits review. We all know that. Every court in Australia and England has said that at one time or another. It's not a merits review, it's about legality, it's about separation of powers, whatever it might be. But that's just telling you what it's not about. But could a reasonable person have made the decision? And the other thing that is often said is, well, I might have made a different decision. I probably would have, but I can't say that decision's unreasonable. Now, is that what the test, could a reasonable person have made the decision? Is that what that test is? So that's a possibility. That's possibility number two. The third possibility is that we could adopt a proportionality analysis as either a new ground, that's, if you like, possibility A of the three possibilities, as a new ground, or we could adopt it in a modified form, and I'll explain what I mean by that in a moment, as an aspect of or a way of testing unreasonableness. So that's basically what I'm...
May I
Sure.
interrupt here? Mike?
Sure.
I think many people in the legal academics and professionals are concerned about what the government might do with regard to the judicial review here for purely political reasons. And of course, we have adopted proportionality here,
Yes.
as part of the EU law. So obviously, with Brexit, they've got an ideal excuse to remove that
Yes.
from the grounds.
Yeah. Well, that's true. The only comment I'd make about that is, and I'm a bit tentative because I've really just been looking at the English position for the last couple of weeks, but there are two differences between England and Australia. One is the EU law, so the various treaties and so on which involve the doctrine of proportionality, and two, the Human Rights Act. And so even if in some ways, well, the EU treaty about free movement of goods or free movement of people is to be put to one side, you still have the Human Rights Act.
But that's also threatened.
Well, that fair enough. That sort of negates the point that I make, but it would have to be both, because the Human Rights Act is really it gives rise to the major proportionality issues. So that's where I'm heading now. If I could just say a couple of things about the Australian system, and I apologise if you know all of these things, but it may help. We have a federal system governed by a constitution which allocates legislative powers to the Commonwealth and the states. That allocation is done by identifying particular subject matters and giving those powers to the Commonwealth. I think other constitutions do it the other way around. They say the states have got these powers, and basically the central government's got the rest. But we allocate to the Commonwealth, and then the states have got the rest. For reasons I don't need to go into, the overwhelming balance in terms of legislative and financial power in Australia lies with the Commonwealth. And for reasons that are perhaps obvious, I'd mention that there cannot be such a thing as an unlimited statutory discretion under our system, because the act or regulation conferring the discretion is itself limited to the constitutional power under which it's made. So Parliament, I can't imagine Parliament would actually try this, but can't say this discretion is unlimited by any considerations, because it will be under a statute that has to be linked back to a Commonwealth power. We also have quite a strict separation of powers doctrine under our Constitution, particularly as regards the judicial power of the Commonwealth. It's invested in the High Court and such other federal courts as the Commonwealth Parliament creates. The thing about our separation of powers is that the federal courts are the only bodies that can exercise judicial powers in Australia, and the flip side is that you can only confer judicial powers on the federal courts. So subject to some historical exceptions, you can't confer non-judicial power on the federal courts. It's only judicial power, and there's a whole string of cases as to what judicial power means. I've already mentioned that the federal court has Commonwealth has powers of judicial review in relation to Commonwealth administrative decisions. And the source of that power is contained in the Constitution. There's a provision in the Constitution that says prerogative writs can be issued against officers of the Commonwealth. So you get from that all the prerogative writs. That brings with them all of the principles of judicial review. And as I say, they're basically the same as they are in this country. Each of the states also has a common law prerogative writ jurisdiction with respect to state administrative decisions. And the principles are the same because the High Court stands at the apex of both the federal system and the state system. The same range of administrative decisions come before our courts as come before the courts in this country, subject to one matter I'll mention in a moment. Decisions dealing with matters such as migration and citizenship, environmental issues, social security benefits, and the jurisdiction of bodies specifically established to deal with problems associated with serious crime. So they're the sort of broad areas that you might get judicial review. two things I've noticed since I've come here is I read a case called the International Ferry Traders Limited, which I'll mention again in a moment, which was a case concerned with protests by particular groups about sending livestock overseas, and the police devoting resources to protecting the port so that this could take place. And there was an application for judicial review which was ultimately unsuccessful, but it's quite an extraordinary case that I don't think you'd see that sort of case raised in Australia, where quite clearly it involved serious policy issues as to the allocation of resources. And ultimately that was the reason that the judicial review application was dismissed. But I was struck by that case. And the other thing is we're not going through the same sort of debate, and we haven't gone through the same sort of debate that appears to be taking place at the moment about judicial review and cutting down judicial review. The sort of thing we get in terms of publicity in Australia is if there's a large development which a protest group tries to stop by protest, can't stop by protests, will often bring an application for judicial review. So, and that will receive some publicity, but there doesn't appear to be any public debate at the moment about whether the judges have got too much power in terms of judicial review and whether they need to have their wings clipped, as I saw a reference to that in a recent newspaper article. So they're the main areas of judicial review. The other thing is that we don't have express rights. There are one or two rights. I think freedom of religion is one in the Constitution, but other than that we don't have a Bill of Rights at the federal level. We do, I think Victoria and the Australian Capital Territory have it at a state level, but we don't have any, we don't have very few rights in our Constitution. We have no Human Rights Act at a Commonwealth level. We recognise, I would think, all of the common law rights, freedom of expression, freedom of association and so on, as the English do, but we don't have those statutory rights, and that is a big difference between the two countries. And I would say also that we have a Conservative government at the moment. Although it's raised from time to time, it's unlikely that a Human Rights Act is on the horizon. So that's just basic information. I want to now turn in a little more detail to Wednesbury unreasonableness. First of all, it's restricted to, in Australia, it's restricted to statutory discretion. It doesn't go, the doctrine doesn't go outside statutory discretion. I think in some places it will also apply where you have a provision that says if X is satisfied of Y, then he or she can do Z. And the courts will oftentimes read into, if X is satisfied, a requirement that X be reasonably satisfied. And what does it mean to say reasonably satisfied? And the courts, or in some places, will read in Wednesbury unreasonableness into that inquiry. That's not the position in Australia. We're talking about a statutory discretion to be exercised, and that's where Wednesbury unreasonableness applies. So what I'm looking at is not, I don't know how many people are familiar with what Lord Green said in Wednesbury, but he said, well look, all the specific errors like purpose and relevancy and so on, which I talked about, they are in effect all a form of unreasonableness in themselves. So you can actually see all the judicial review errors as being a form of unreasonableness. But I'm not talking about that. I'm talking about the cases where the unreasonableness doesn't consist in a specific error, so that you've got an exercise of power, all relevant considerations appear to have been taken into account, no improper purpose, no bad faith, and one is saying, in what circumstances can the court say that decision is invalid? Now, I mentioned that until recently we had the traditional Wednesbury test, and that's reinforced by the fact that we had a lot of activity in Australia in the mid-1970s. We had an Administrative Decisions Judicial Review Act, which actually, I think in 1977, which identified certain Commonwealth decisions and said those decisions can be reviewed on these grounds, and it stated basically the common law grounds, including the Wednesbury test in the terms that I've outlined, so unreasonable that no reasonable person could make it. And then we had an Administrative Appeals Tribunal Act, which identified a whole series of decisions made by government that could be reviewed by the Administrative Appeals Tribunal. But the point I make is that in the mid-1970s, Parliament adopted the Wednesbury test in the extreme form that it has been expressed. I'll come back to this, but there's an important decision in Australia in 1990 where a judge of the High Court referred to the test in its usual terms and referred to it as being extremely confined. Other adjectives have been and phrases have been used to describe the test over the years, including arbitrary, capricious, bizarre, and then of course in the CCSU case, Lord Diplock referred to irrationality as being the test, or so outrageous in its defiance of logic or of accepted moral standards, no sensible person who had applied his mind to the question could have arrived at the decision which is under challenge. So, 2013 comes along, and there's a suggestion that there's a decision of a tribunal, the Administrative Appeals Tribunal, that was unreasonable in a Wednesbury sense. Now, can I just tell you a little bit about this case? Because it was an application for an adjournment before the Administrative Appeals Tribunal. It was a migration case. It was someone who had come to Australia, and if they had obtained a certificate from a training authority, then they could get a visa, a skilled visa. There'd been some fraud associated with an earlier application that had been made for this certificate, which was unknown to the visa applicant. the visa applicant then made another application for the certificate that they needed before the tribunal, and the training authority delayed in providing the certificate. So the person goes to the tribunal and says, please adjourn, I'm waiting for this certificate, I anticipate I'll get this certificate, I've filled out all the qualifications and so on. And the tribunal refused to adjourn the case and dismissed the application for review. And it was said that that exercise of the power, an exercise of the power to adjourn the case, was exercised unreasonably. And our traditional test was that so unreasonable that no reasonable tribunal could make that decision. The High Court in that case found that the decision was unreasonable and set aside the decision. That simply meant that the review application was reinstated and would go back and be decided by the tribunal. But they made some important points in the course of doing that. First, they said that the requirement of reasonableness is an implied legislative intention. It was expressed in various ways. That's one way, an implied legislative intention. Another was a presumption of law. The legislature is taken to intend that the discretionary power statutorily conferred will be exercised reasonably, and it becomes a condition on the exercise of the power. So, just as in, I think, Cooper and the Wandsworth Board of Works back in the 1860s, Justice Biles said that there was an obligation to provide procedural fairness, although in that case he said the omission of the common law, the omission of the legislation will be remedied by the common law. The court in this case that I'm referring to is saying, no, we're going to say in every piece of legislation there is a presumption of law that the power is to be exercised reasonably. That's a presumption of law. It's similar to the obligation to provide procedural fairness. So that's the basis of it. The next thing that the court said is that the test of legal unreasonableness is not confined to decisions which satisfy what I've been calling the Wednesbury test. So you don't need to show that the decisions arrived at is irrational or a bizarre decision. So far, so good. And then, so one then poses the question, what did they say about what the test now is? And can I just then make these suggestions, I suppose, as to what the test might be? Because the court mentioned a number of possibilities. First of all, they referred to probably an allied area of the law. So we've been talking about statutory discretions. An allied area is unreasonableness in the context of an exercise of a power to make delegated legislation. And in that respect, they referred to a decision going back to 1898 as helpful, and that decision said that a bylaw, for example, would be unreasonable if, one, it's partial or unequal in its operation, as between different classes. Two, it is a measure which is manifestly unjust. And three, the measure discloses bad faith. Or four, the measure involves such oppression or gratuitous interference with the rights of those subject to them as could find no justification in the minds of reasonable men. So that's the sort of bylaw test, and the court is saying, well, maybe that's a good indication of unreasonableness in the context of a statutory discretion. A couple of things about that test. Unequal treatment or discrimination between groups is often a very good indication that the power's been exercised unreasonably. And secondly, you'll notice that one of the things I said there, a gratuitous interference with the rights of those subject to them as could find no justification in the minds of reasonable men. That's sort of 1898, but it's got a sort of very broad analogy with human rights and the proportionality type analysis, which I'll refer to a little bit later. So that was one possibility. The second was Lord Diplock's formulation in the Tameside case, where his lordship said this: no sensible authority acting with due appreciation of its responsibilities would have so decided. Now, if you're like me, you're thinking at this stage, well, sounds all right, but how do we apply that? How do we say to the community, how do we say to the people that are making these administrative decisions, that's why your decision's been set aside? So that's number two. Number three is that you adopt an analogy with the circumstances in which an appellate court interferes with the exercise of a judicial discretion. And here comes what I think is probably the test as it stands at the moment. Is the decision a decision which lacks an evident and intelligible justification? Now that's, I think, as I say, I think that's where we probably stand at the moment, that's the test of what is unreasonable. Is it a decision that lacks an evident and intelligible justification? Now, so that's that case. 5 years later, in 2018, we have another case which raises unreasonableness, and believe it or not, it's also a case about a journey by the tribunal. And in that case, the applicants for a visa had a history of non-attendance before the various administrative bodies, and the tribunal invited them to a hearing, as it's required to do under the legislation. They didn't attend. The tribunal struck out their application for review, and the question was that decision unreasonable? The High Court in that case said no, it was not unreasonable. You did everything you were required to do under the legislation. These people had a history of, in effect, not attending hearings that they were invited to, so no unreasonableness in that case. But the test of lacking an evident and intelligible justification came through in that case as well. So we're left with the position, just try and hurry things up a bit, where we know Wednesbury unreasonableness is not, as so expressed by Lord Green's, not the test. So we know that something's appearing from the shadows, more effective than what has been there in the past. But we're not, and we know that what's been suggested is a decision that lacks an evident or intelligible justification. But as I'll mention in a moment, there are a couple of problems with that test. First is, rather suggests that there is a prior question there. I mean, if you've got a whole array of administrative decisions and someone stands up and says, well, that decision's unreasonable, do you immediately say, well, is there an evident or intelligible justification for this? Or is there a prior question that you look at the decision and say, gee, that looks a bit very odd decision, therefore there needs to be a justification which is both evident and intelligible. Why does the justification need to be evident? I mean, you need to be able to see it, you need to be able to discern it, but is there some particular meaning to evident? Does it need to be clear on its face? Is that what the court's saying? Intelligible, that's quite understandable. That's a phrase used in the English cases. Justification, that's quite understandable too, but does it mean that there's some shifting of the onus? The law in Australia is that the person challenging an administrative decision must make out the grounds, including unreasonableness. So when you talk about a justification, is that suggesting a shift of the onus? So those are the questions. And how satisfactory is that as a test? Is it simply saying, I can read the reasons, if there are reasons, and yes, they make sense, they're intelligible. But is there something in the word justification? Is there a notion of proportionality in the word justification? So those are the questions that arise. The issue that I was looking at was, well, what's the position in England at the moment? What are they saying? And so much of our law comes from the English law. What are they saying about the test? Can that be of any help in elaborating on the test? Do we need to worry about a test? I mean, if you go back to, I mentioned that bylaw case, but there's a case in 1891 in Sharp and Wakefield. Lord Halsbury said that a statutory discretion must be exercised, and I quote, according to rules of reason and justice, not according to private opinion, according to law and not humour, not in an arbitrary, vague or fanciful way, but legal and regular, and within the limit to which an honest man, competent to the discharge of his office, ought to confine himself. So the question arises, to what extent can we just leave it to the court to say, we'll pick up the red-headed school teacher example, but we'll go further than that. We'll keep the administrative body on the right track without ourselves getting involved in policy, without ourselves making some very difficult decisions about resources, but you can trust us with a general test which can be applied sensibly. So that's one way of looking at it. The other way of looking at it is, well, what about the community? are they entitled to more detail as to the basis upon which the courts are interfering in some very important policy areas about resources, about the environment, about terrorism, about various rights and so on? Are they entitled to, even if it's a broad test, are they entitled to know exactly? Will it promote good administration if the test is left vague and something of a catch-all test? Or is it better that it be a more precise test so the administrators can know why they've gone wrong if that's the decision of the court? As I've said, in looking at the English cases, the first thing to note are the influence of the European Treaty and proportionality, and also the influence of the Human Rights Act. But before I go to just some of those cases, I'm sorry I've been talking longer than I had intended, but can I just mention some issue? I mean, when we're looking at reasonableness, what are we looking at? Are we looking at ultra vires? Are we looking at legality as against merits? Are we looking at a rule of law consideration? Are we looking at separation of powers? Are we looking at abuse of discretion? Now, Lord Reid, R-E-I-D, Lord Reid, in 1970, said the word unreasonable is not at all an apt description of action in excess of power, and not a very satisfactory description of action in abuse of power. So, failure to take into account a relevant consideration, you can say this statute, even though it's very general, identifies these as relevant considerations. You haven't taken that into account, therefore you've made a decision beyond power. Now, one can look at that and feel reasonably satisfied that that amounts to an ultra vires legality type approach to the issue. And similarly with improper purpose, Parliament gave you this power to exercise for this purpose, you've exercised. But with reasonableness, what are we talking about? Power. Lord Green, after all, said in Wednesbury that there was this catch-all which applied even though the decision fell within the four corners, that was the expression he used, of the discretion. I mentioned an influential decision in 1990 in Australia by a judge who later became the Chief Justice. And his explanation for judicial review in Australia is that it's an emanation of the court's duty to declare and enforce the law, and in fact referred back to what Chief Justice Marshall said in Marbury and Madison, that the court's duty is to declare and enforce the law. And he went on to say, if administrative error is cured in the process, well and good, but that's not actually the purpose of judicial review. The basis for judicial review is the court is saying, this is the law, you've exceeded your power in these circumstances. The merits are not an issue, and as a matter of definition, judicial review is concerned with the extent of power and the legality of its exercise, and not with the protection of individual interests. And that's important in the Australian context because we don't have the Human Rights Act feeding into the way judicial review applies. He went on to say, the one ground which might appear to open the gate to a review of the merits is Wednesbury, but it does not do that. It is extremely confined. It is only engaged where what has happened is properly described as an abuse of power. So we're back into issues of power, which seem to be the juridical basis of Wednesbury unreasonableness. I notice from a couple of cases that both the English judges and Australian judges have given as reasons for confining Wednesbury unreasonableness. Lord Lowry, in a case called Brynd in 1991, said there were 4 reasons. I think the last one was a bit dubious with respect, but the first was that Parliament had entrusted the decision to the administrative decision maker, not to the court. So that's the first reason you confine reasonableness. Secondly, the court's lack of expertise in a number of areas where you've got policy issues, foreign policy, national security, matters of high politics, although the Gina Miller case suggests that wasn't a locked gate. The third thing was the need for certainty and stability in administrative decision making. I think that point's being made there is that quite often you need to make the decisions quickly. If you're going to have challenges that might take years to go through the courts, you're going to unsettle the administrative decision. And then the fourth thing that the English judge referred to was the proliferation in the number of judicial review applications. I can't think that that's a very strong reason. Our judge, who expressed really similar matters that they're with a slightly different emphasis. The reason you confine reasonableness in Australia is because of the separation of powers doctrine embodied in the Constitution, and he expressed it in these words: the authority of the judicature is not derived from some superior capacity to balance the interests of the community against those of the individual. When he's referred to some superior capacity, he's referring to there's no superior capacity for the judiciary over the executive or over the legislature to balance those interests. That's not the way it works. Secondly, he referred to the policy matters. Thirdly, he said if you have a broader view of reasonableness, you skew matters in favour of the rich, the powerful, or simply the litigious. So that basically you give someone an opportunity to play the system who's got deep pockets and can keep challenging these decisions. So those were the matters. Now, I'm just starting to wonder if I've run out of time. Colin, I've got some... Yeah.
Happy for you to continue if you want. We have the room, so if you're happy to go on, up to yourself.
May I just
sure.
go back to what you were saying about the power over delegated legislation?
Yeah.
Because in one jurisdiction I did some drafting, they applied the ultra vires rule very rigidly, and I had to go around the alphabet 3 times to list all the things that the minister could make regulations on. But in most other jurisdictions they seem to be much more relaxed and just have some general phrase about any matters, pertinent matters.
Yeah.
So I think in the first situation, there will hardly be any sort of situation where you would actually need to apply any reasonableness test, but where you're more where the legislation is more vague, I could see more scope.
Yes. Yeah. Well, we have a where you've got a purposive power. We have a doctrine that you look at whether the say in that case a bylaw, was reasonably appropriate and adapted to the purpose for which the power was given. And that invokes a type of proportionality analysis. It's not exactly the same as the proportionality analysis that's adopted here under the Human Rights Act, but it's quite similar to it. But generally the cases on challenging bylaws in Australia have not been successful, I think, would be fair to say. All right, well I might just continue on a little bit. Just in terms of the English cases, I've already mentioned the International Ferries case. Look, I won't go through the cases, it'll take too much time. I've got 6 of them, and I'm going to do a paper before I leave, so that can be read if people wish to before I go. But the sum total of the cases, I think, in England, as I would read it, is that at the moment, in a non-EU case, non-human rights case, so neither of those issues are involved in the case, Wednesbury unreasonableness applies with varying intensity of review, and that developed before the Human Rights Act, where the House of Lords said where there might be, say, common law rights or convention rights at that stage, will apply a greater degree of scrutiny to the case, will require greater justification if the interference was with an important right or was great interference. So you look at the importance of the right and the degree of interference. So in those sorts of cases, Wednesbury's there, but there's some sort of sliding scale in terms of review. In the case of involving human rights or EU law, but let's put EU law because they're a rather special category, but say a human rights case, Wednesbury applies with varying degrees of intensity. Proportionality applies with varying degrees of intensity. And of course, you probably be aware that proportionality involves the 4 steps that were laid down in, I think, Bank Mallet. There were 4 steps. The one that's really interesting, or the 2 that are really interesting, are the 3rd step, which involves a consideration of whether the measure is necessary. Because the big question there is, what do you mean by asking whether the measure is necessary? There's a well-known quote from an American judge under their constitution who said that any lawyer that can't think of a less intrusive way of expressing this, which won't broadly affect the purpose, isn't really worth his or her salt. So necessary can't be taken literally. You have to allow some sort of scope for saying, okay, well you could think of something that's slightly less intrusive with the right, but that doesn't mean that we're going to say it's not proportionate. So that's always, that 3rd stage is very interesting, and then the 4th stage is the balancing the actual proportionality. Is this proportionate interference to the interests served by the legislation? So that's the sort of full-blown proportionality test, as I understand it. And I may be wrong about this. If you're talking about the Strasbourg Court, that's the Human Rights Court, they will allow a margin of appreciation on the basis that a particular state will know more about its circumstances, etc., etc. If you're talking about a national court applying human rights, then it's not a margin of appreciation. It's a zone of proportionality, so there's sort of a deference allowance there, but it's less than that allowed for the Human Rights Court in Strasbourg. So that's the proportionality test. Can it be, and Professor Craig in his book on administrative law says, well look, you know, should we have traditional Wednesbury? Should we have modified Wednesbury, which is the intensity of review plus proportionality? Or should we just let Wednesbury go and just have proportionality in lieu of reasonableness? Now, I mean, that's an interesting debate, and it's a real possibility that could happen. I don't think it would happen in Australia because we don't have proportionality in this area. We do have it in some other areas, or at least something very similar. I mentioned that reasonably appropriate and adapted to the statutory purpose in the case of purposive power. So we have that doctrine, and it's pretty close to proportionality, but it's not actually that. So we would actually, our courts would be introducing a new ground of review in proportionality. But that wouldn't mean that we couldn't have a Wednesbury reasonableness test with an element of proportionality in it, some sort of modified proportionality where we could say not the 4 steps, that's very detailed, but where in deciding whether the decision is reasonable or unreasonable, we could look at proportionality in its modified form. And in fact, there have been a few cases which have suggested that. Can I just go back to that first Australian case I mentioned where the High Court said the decision was unreasonable to refuse the application for an adjournment and just to dismiss the application for review. One of the judges said, well look, the tribunal said here, these people have had enough chance to put their case, so we're going to dismiss the application. And this particular judge said, well that's probably a disproportionate exercise of power to adjourn or not to adjourn. So there's this notion of proportionality comes in. It doesn't necessarily involve the 4 steps under the Human Rights Act and so on, but it could come in as I think the High Court's at a couple of say that it's an analytical tool for deciding whether a decision is unreasonable or irrational. There's more I could say, but I think I might. That's the bones of it.